Mr. Don Susantha Katugampala, Accredited Immigration Law Specialist and a lawyer and founder of FAIRFIELDS Lawyers, Melbourne. Ayubowan.
Ayubowan.
So it's a complex process and I would say a long process as well, but someone can still stay in Australia while the process is being taken.
Absolutely, yes. The bridging visas are given. If you lodge an application on a substantive visa, then you'll be granted a bridging visa A. So a bridging visa A will be valid until the tribunal make a decision. And if the tribunal refuses your matter, then you appeal to the courts, then you lodge a new bridging visa application, then your bridging visa A will continue, and most probably with work rights. And then if you appeal to the minister, then you have no other visa option but to have a bridging visa E. Bridging visa E will give you work rights if you appeal to the minister on time, if you lodge your bridging visa on time. So the timelines are very important. At the same time that when you lodge your application, when you submit your documents to the department, it's important that you submit genuine documents and correct information to the Department of Home Affairs, because if you provide incorrect information or fraudulent documents, your visa can be refused on public interest criteria 4020. If your visa is refused on 4020, then you are likely to have an exclusion period of 3 years from the date of refusal. You can't be granted any other visa in that period. You're subject to an exclusion period. Therefore, it's very important that you don't provide wrong documents, you don't provide fraudulent documents, you provide correct information, and you answer every question correctly in order to avoid any refusals on public interest criteria. Any refusals on any other criteria other than providing incorrect information won't be detrimental, and it could be the department ignorance of some matters. Then you have the right to appeal, you can win the appeal. But if you're refused on 4020 public interest criteria, your matter is quite serious, then you need to get proper legal advice in order to secure your chances. Migration law is always a very complex area of law. It's important that you have correct advice, especially in the appeal stage, from a lawyer, a legal practitioner. That way you can still have success in your matter.
So as an accredited immigration law specialist, I know that you're working very closely with tribunal. So what is your retaining rate? Because you always say that you deliver the results.
Yes, the tribunal member is quite independent from the department. Mainly they are lawyers or academics, and they will look at the applicant's matter on fresh eyes, fair manner. So if you can engage with the tribunal member, that's our ability to be able to negotiate with the Australian employers or the tribunal members or the department or the state governments for your success. The outcome is yours, not mine, but your outcome is my outcome. So we always work towards the outcome. So our principle is to deliver results. We need to deliver results. If you start your journey and if you stay in your immigration journey from start to finish, from beginning to the end, we will never let you down. We will make sure we get you the result. And the appeals to the tribunals, we have great success. That's the pride that we have in our practice.
Thank you very much, Mr. Don Susantha Katugampala, lawyer, accredited immigration law specialist and founder of FAIRFIELDS Lawyers, Melbourne.